are pretty strong.
Honourable Leanne Dalziel.
Mr. Chairman, I kind of want to thank the member for attempting to put some history on the record, but he's actually quite wrong, and I think it is important to highlight the major difference. He said that we had introduced the Serious Fraud Office, that a Labor government had introduced the Serious Fraud Office and had given it extended powers, or had increased its powers. It didn't. We established the powers of the Serious Fraud Office, and we didn't give them powers that were currently held by the police. They had a special status in the legislation because they were dealing with such high-level fraud. Now, when a government establishes a new agency with significant powers, as we did with the Serious Fraud Office, it does actually pay to have a look at how that has operated in practice. And actually, I don't think that anyone was very satisfied with how the Serious Fraud Office had utilised some of its powers, and we've heard some discussion around media, which is why we'll deal with that when we get to the wider part of the bill. But the reason we can focus on the Serious Fraud Office is my colleague's amendment, where he brings this into the definition section. And I think that what the Law Commission actually recommended, and I think Simon Bridges might do well to reflect on what he tried to advise the House, is that the Law Commission said take the powers away from the Serious Fraud Office. So they weren't saying, extend the powers to the police. They were saying take it away from the Serious Fraud Office. But as it turned out, there was a very simple solution to all of this, because the previous government that was the initiator of this legislation, the previous government actually wanted to re-merge the Serious Fraud Office into the police. And so therefore disband the Serious Fraud Office and put all of its functions within the police. And I'll tell you what, there are a lot of people in the police force that believe the decision to separate it off from the police should never have occurred in the first place. And the reason is, well, the reason that, I'm getting chipped by the member across the way because they don't want to be involved in that sort of crime. I think a former chair of a select committee who's a former police officer and a former lawyer will actually tell you exactly what I'm telling you, and that is that the police never recommended it, and I can tell him that the amount of concern that was expressed to a previous Labor government when Richard Prebble was the Minister of Police was extraordinary. And the point that I want to make is that it was made very clear by the Law Commission that there was no need to expand these powers. In fact, they recommended that they not be carried over. And that was the decision that we made. So let me just read this out. This is the history as written to the previous Minister of Justice by our own Shadow Attorney General at the time, saying, "The genesis of this lies in the proposal by the last government to merge the Serious Fraud Office into a new organised crime and serious fraud unit within the police. At the time, the Law Commission advised the then Cabinet that the SFO was in the habit of routinely using their powers to use production and examination orders. These orders do erode the right to silence and should be used sparingly. They were never intended to be a substitute for normal investigative practice, but rather were intended as a reserve power to be used to unpick serious fraud when normal investigative means will not suffice. They enable information to be gathered from mainly third parties who hold information as agents who owe their principals a duty of confidence, but who are able to cooperate given the legal authority of a production or examination order. Largely because these powers had been overused by the SFO, the recommendation was not to carry these powers over into the new combined agency. The proposal to completely remove these powers was criticised, and I actually think members of the then opposition were among the chief critics. The proposal to completely remove these powers so in response, I, with the approval of my then Cabinet colleagues, went to see various Queen's Counsel in Auckland who worked on SFO cases. I met with various prosecution and defence counsel. All of those I met with agreed the SFO was overzealous in its use of their powers, but one also thought it would be wrong to remove the power entirely. I hear members asking when this letter was written. It was written on the 9th of November 2010, Mr Chairman.
Honourable Leanne Delsfield.
And what it then went on to say, that there was, in the end, widespread agreement that the power for the SFO should be constrained but carried forward. We then in Cabinet concluded that if the powers were necessary in a constrained form for the SFO, then a constrained version of the powers was justified for police investigations of serious organised crime, some of which bears similarities with the complexity of serious fraud and can be more pernicious. And the point was made that the national opposition at that time campaigned against the merger of the SFO into the police and upon election halted that merger. The proposal to confer upon the police to obtain production and examination orders when investigating serious organised crime, however, continued and is being given effect to by this bill. And that's where I totally disagree with Simon Bridges. This is extending the power of search and surveillance, the production of examination, and it's for the police. And they're matching it with a power that's have been overused and abused by the Serious Fraud Office. And that is this opposition's objection to this part of the bill going through without reintegrating the Serious Fraud Office into the legislative framework. Because the way that the legislation was originally framed was an assumption, was our assumption, that there would be a merger between the two organisations and those powers would be carried forward but in a modified form. But what's really happened is that the government said, well, these are the Serious Fraud Office powers, we'll just give those powers to the police. And they're more constrained for the police, but it does make a nonsense of bringing the whole thing together. So it is really important that the Serious Fraud Office is included as part of this legislation. It is important because I think that the government has agreed simply to subject the Serious Fraud Office to reporting conditions, but the bottom line is that doesn't solve the problem that we've got in terms of the way the Serious Fraud Office has been operating, and to have them excluded from the operation of the bill actually prevents us from using this one opportunity to resolve the outstanding issue, which is they have been using the examination orders that were supposed to be used in a relatively rare environment. They've been using them in a way that was totally unexpected by the government of the day and expedient too in terms of their real obligations to investigate matters. And if people think that this doesn't matter, and it does tie back into this whole question of access to to information that's been collected, for example, by the media, the one thing that protects people from the public's, protects people from being ripped off by finance companies and things like that, are when the media are threatened by, with defamation suits if they are to expose these goings on, and if they know that information that they've received in confidence can in fact be disclosed to the Serious Fraud Office and held by them, then that's going to make it very, very difficult for people to come forward and be as open with them as they possibly can. So I think that this is a very simple amendment that wasn't possible when it was in front of the Select Committee. Without essentially without an instruction from the House to this committee to make the amendment. That's no longer the case, and I therefore think that there is really nothing standing in the way in making this the expansion to cover the Serious Fraud Office as mentioned in the amendment moved by my colleague, the Honourable David Parker, and then also at that point to address the anomaly that then exists between the two, because I think there is an important reason why we need to have a uniform approach in this particular area, and the serious fraud office approach is not the one that we want to see continued in this House, and that's why we're not supporting the passage of the bill. And I do agree that there isn't much that is left that divides us, but this is a critical point of division, and if we could find a resolution to this and the other matter that's standing before us but isn't subject to this particular part of the bill, then I believe that we would be able to get the level of passing in this House that we should find acceptable in this arena.
Honourable Phil Goff.
Mr. Chairman, I'd like to